Hello! In today's episode of America, SCOTUS and the VRA. I know. Who comes up with these acronyms? SCOTUS? Really? Anyway, I'm Rebecca Farnum. Welcome to Ramblings with Rebecca, and today, what the heck happened with the Voting Rights Act? You may have missed this because the internet was kind of taken over in a wave of jubilation over the strike down of the Defense of Marriage Act and the business with Prop 8. However, the day before these two very important decisions were announced, another incredibly influential decision from the Supreme Court was announced and equally deserving of attention. The Voting Rights Act. You may have heard of it. It was kind of a big deal. 1965. We actually gave people in America the vote and said, no, we should actually let them vote instead of just, having a line in the Constitution saying they can vote and maybe they're people. So, big frickin' deal. However, a couple days ago, in a 5-4 ruling led by Chief Justice Roberts, the Supreme Court said that Section 4 of the Voting Rights Act is unconstitutional. What is Section 4, you ask? Section 4 of the Voting Rights Act is the formula that gives the VRA any kind of teeth, basically. When the Voting Rights Act of 1965 was passed, it came with a variety of measures to make sure that blacks and others actually got to vote. Most notably of this was the fact that several parts of the country were required to have federal oversight over any change in their voting laws. So this includes things like IDs or any kind of new test or something to get people into the polls and actually allowed to vote. It also involved districting, so the way we split and draw lines around areas to count the votes in the electoral system. Any change to those required federal okay checkmark. Section 4 is the formula that said which parts of the country had to have those any changes in those voting laws cleared. The 5-4 ruling majority said that that formula is now outdated and thus unconstitutional. It very carefully did not strike down Section 5, which says the pre-clearance based on this formula is necessary. However, we currently now have a law that says if states or regions fall into this formula, they need to have their changes cleared, but there's no formula, so bye-bye, go with the teeth. Recently, these parts of the Voting Rights Act have been used to block a voter ID law in Texas and delay another similar one in South Carolina. Those two states can now enforce those laws as quickly as they would like because the piece of legislation that was used to say, no, you can't do that, has just been nullified. Basically, the majority opinion said that Congress really needs to do a new formula, and they will consider that. It's the outdated formula that is unconstitutional, not the idea itself. So this is decently good news, kind of. The Obama administration was almost certainly actually expecting them to completely nix Section 5 as well. So there is hope, in a way. However, pretty much everyone agrees that probably Congress is not going to rush to creating a new formula for a variety of reasons. In 2006, Congress did reauthorize the Voting Rights Act, recognizing in the rhetoric that second-generation issues around balloting and access to the polls were still very present, unless the same formula was in fact still applicable. That's what the minority opinion from the Supreme Court saying, no, this formula is still legit and we still need to provide protections kind of rested on. However, at present, the Voting Rights Act has very, very little teeth. States can do all kinds of laws to block segments of the population whose vote they don't really want to count. Now, of course, I don't really want the formula to be necessary. I would love for Congress to not have to do one. Unfortunately, discrimination and racism are still very, very present in America, and institutional protections are still necessary. So Get it together!